fought through not only state Supreme Courts like the Missouri Supreme Court we just had an issue on, but it's also been fought all the way to the United States Supreme Court. So not only are there laws and statutes that dictate unemployment, but there's also case law that determines and makes and influences the determinations in the adjudication process, as well as the financing of the unemployment system. And each state has different laws and different ways that they handle unemployment. In some states, you might have a scenario where there is very explicit ways of handling a certain type of claim. And then right next door to you in the different state, they will handle this in a completely different way. But each state has the ability to go in and to determine how the adjudication process will occur, how they fund their system, all types of different things they can manipulate. They do have to meet certain federal requirements, but they are allowed to make these determinations based entirely upon the political environment at the time in their state. One thing you probably have guessed over the years, if you've dealt with this at all for any length of time, is that unemployment is politically influenced probably more than any other type of labor law. It's really easy, and when the economy is tough, then legislatures generally will react more favorably to more unemployment as opposed to when the times are prosperous and you see laws like what you've seen recently and across the nation where it's limiting the number of weeks of unemployment. The biggest thing, if you get nothing out of this, and you probably already know this, the system is inherently biased in favor of the claimant. And what we're going to be talking a lot about during this course of this seminar is discussing how we can overcome this bias. And it obviously is understandable. You have an adjudicator who's looking at the unemployment claim, and they're talking to poor Joe who has been recently unemployed. He has a mortgage, he has a car payment, he has kids, he has a wife. Joe's unemployed. Well, then you're contrasted with the nameless, faceless organization who everybody knows automatically assumes that you have millions of dollars in reserve and that you can afford to pay poor Joe his unemployment. So the system is incredibly biased in favor of the claimant. But there's ways around getting around that bias, and we're going to talk a little bit about that. The laws that dictate unemployment often conflict with employers' policies or even other laws. Attendance is a perfect example of that. In attendance-related unemployment claims, the state almost is always asking you why the claimant was absent or tardy, especially absenteeism. Well, as we all know, many of you are in the human resource world, you cannot ask employees about their medical conditions. You can't ask them to provide you more detail than they are willing to provide you. You have to take on the face value that what they're telling you is truthful. This often conflicts with the privacy laws of health, for example, often conflicts with the state statutes that dictate attendance violations because the state law wants to know the reason why so they can establish what's called good cause for being absent. So there's, as I'm sure you're not shocked to hear, the laws that dictate unemployment often are in direct conflict with laws that dictate other things, and because there's usually no kind of reconciliation that goes on between the passage of different pieces of legislation. The great news about this is that unemployment can be controlled with a combination of good human resource practices and an assertive approach to claim management. As you all know, we are very aggressive when we protest claims on your behalf. We look for ways to contest an unemployment claim. But it comes back down to our effectiveness is only as good as the documentation and the information that we can provide to the state. Many of you take advantage of the proactive nature that we provide, and that's wonderful. But oftentimes, even even then, a lot of employers will make mistakes, and they will commit errors unintentionally that hamper your cause in fighting the unemployment claim. But if you buy into this type of program, and if you really make an effort to formulate your documentation that takes into account unemployment, you're going to have a much higher success at preventing unemployment claims. Here's some of the common mistakes that people make, employers make. First of all, when they're fighting the unemployment claim, they don't understand what it is they're trying to prove. Okay, and it goes back to a lack of knowledge of the unemployment laws and what regulations dictate when a disqualification is going to occur. That's not because you are necessarily, it's no fault of your own. It's just that many employers obviously do not deal with this on a regular basis. We're in a unique circumstance that we deal with this 24/7. So obviously we're in a position to understand what it is that is going to take to get a disqualification based on whatever type of topic it is. The other mistake we often see is that they provide too many topics in the documentation. There is a tendency to take everything the employee did wrong and throw it in a written warning. Well, what that does for the adjudicators is it really muddies the issue. It makes it, especially when you get to the final incident, it really detracts from the issue that you're trying to prove that is related almost exclusively to the final incident. So whenever you combine written warnings and you distract from the issue, the primary issue that leads to termination, that it's detrimental to the unemployment claim, your cause, because it really it distracts the adjudicator from looking at what you're trying to really prove. At hearings, especially, this is true, you have the wrong witness or the wrong information. The wrong witness is particularly important because more often than not, the individuals who are participating in this call are senior level managers. So they are individuals who have more of a corporate responsibility than a supervisory responsibility of each individual employee under their department. Hearsay evidence is allowable, but it's only given the weight that it is deserving. Okay, so unlike a court of law, hearsay is not admissible. You can get it in at an unemployment hearing, but what happens is that it's only going to be given the weight it deserves in contrast to the testimony that it opposes. So if the claimant, who obviously is going to be providing firsthand testimony from their perspective, testifies against strictly hearsay evidence and strictly hearsay testimony, the claimant is going to be given the upper hand. So always make sure when we prepare your witnesses at unemployment hearings, you probably have heard it many times, who saw what, who was there at the time of the incident, and that is because we have to get as close as we possibly can to that first-hand information in order to be effective in the unemployment claim. The next one is inconsistent or poorly defined rules and expectations. It's really hard, obviously, for a claimant to know that you're inconsistently applying a certain practice or policy during the course of their employment. But as I said, I've been doing this for 20 years. I have seen many times when a claimant has called former employees as witnesses to the unemployment hearing, and then they will testify on the claimant's behalf that the employer has not been following their own policies and procedures. Also, sometimes employers actually contradict themselves in between different warnings, and they misrepresent or they misstate policies. They don't follow their own policies and everything. You have to make sure that you follow your own policies. Otherwise, it's going to be a very uncomfortable period of time for you when it comes to the unemployment hearing, because the referee is going to point that out to you. They're going, if you've ever been through a hearing like that, you know how awkward that can possibly be, that you have to explain why you didn't follow your own policy. No documentation. That's one of the biggest things that we are confronted with is employers assume. Never assume anything. The unemployment system is, as I mentioned, inherently biased in favor of the the claimant. No matter how egregious you think that incident is, document it. Document it as best as you possibly can, because nothing is assumed. And remember, almost always the claimant is going to go to the unemployment office, and no matter how obvious and how clear you've made the reasons why they've been terminated, they are going to develop convenient amnesia. They're not going to admit to anything. Documentation is your only line of defense to overcome this inherently biased position that the state's going to take in favor of the claimant. Also, make sure that the documentation is signed. While you can't make them sign it and you can't make them acknowledge it, you can provide witnesses that it was provided to them. You can countersign it. The worst thing that you can ever do in a hearing especially is to provide documentation that you said you gave to the claimant, but you find that none of the documents have been signed by anybody. If they won't sign it, at least acknowledge that they won't sign it, you sign it, and have a witness countersign it. Finally, this is a big one. They keep poor performers too long. In nearly every state that operates, there's a couple of exceptions, but in nearly every state, an employee who is dismissed in the first 90 to 120 days of their employment, even if you lose the unemployment claim, your cost is zero. The liability for an unemployment claim in the first 120 days for most employers is going to be zero. And the reason why is because the liability is established based on what's called the base period. The base period is a set of rotating calendar quarters that determine the liability and the liable employers of each claim. The current calendar quarter is never included in that base period, and the lag quarter, which is the most recently completed calendar quarter, is never included either. So an employee, if you release them in their first 90 to 120 days, you're likely looking at a zero unemployment claim. So if you identify an individual who is a poor performer and you're convinced they're never going to get rid of them as soon as you possibly can, because by doing so, you're only keeping them on, you're only extending your liability potential. The next thing is obviously, as we all know, building the foundation to any of this is consistent and good human resource practices. You got to have good human resource practices. We're very lucky that almost nearly all of our clients have exceptionally good HR practices, or they're willing to listen and implement good human resource practices. And that begins with accurate and timely documentation. The state is going to be looking for accurate and timely documentation that was created at the time of the incident that they're being reprimanded for. You don't want to create an environment where you're trying to recreate documentation, a period of time afterwards, because naturally you're going to miss out on details. You're going to miss out on witnesses, and of course, going back and asking the claimant to document and sign something that happened a week prior is you're not likely going to have a receptive audience at that point. So they're looking for accurate and timely documentation. As I mentioned before, they're looking for consistent application of policies and standards. They want to see that you have a consistent progressive discipline policy in place. The unemployment office is very, very big on seeing a nice linear progression of discipline. If your policy says X, that at certain points they get a verbal, and then at the next stage you get a written, and then maybe they get a final written. They want to see that. They want to see that linear progression in your policy. We can get around that sometimes by showing another part of the disciplinary process. When you reserve the right to jump a step, that's fine. You don't have to always follow that linear process. But unless there is a clearly defined reason why you jump that step in that process, they want to see that progression, because that's what you've told the claimant at the time of hire in your policy handbook. That is what's going to happen, and that is what their expectation is. So they want to see that nice line of progressive discipline. You've got to have good first-hand documentation. Okay, this is going to enhance your chances of prevailing in unemployment substantially. And here's the reason why, is because these are the individuals who are on the firing line. Your frontline supervisors are often going to be in the best position to explain what the claimant should have done and what they did wrong. So make sure that you help these frontline supervisors go through and create documentation that is clear and it has a definitive explanation of what policy was violated. When we do a larger version, a more complex version of this seminar for clients, it's designed for the frontline supervisors, designed for them to understand the importance they have in this process. You are not in a position most of the time to observe what occurred when that employee violated a policy. You have to rely on these individuals. So buy-in of your frontline supervisors is absolutely essential, and educating them on how to document things is an absolute must to maximize your cost savings in this area. Now, when we protest resignations, they're generally the easiest ones possible, okay? But just a couple of things that I want to point out to you is that whenever possible, get a letter of resignation, okay? When I was doing this practical human resource management prior to doing this all these years ago, I always insisted upon the employee putting it down in writing for me. As you all know, that is not always possible. And of course, for those of you who are experienced human resource people, you probably know that if an individual won't put it down in writing, that's your first red flag that something else is happening, okay? So, but whenever possible, we want to get a letter of resignation and we want to get it sent into the unemployment office. One of the things that can be included, and we use this frequently all the time, we've used text messages, we've used emails, we've even used Facebook posts to indicate, and prove that the intent of the claimant was to quit their job. So those are all things that we can possibly use. If the letter of resignation is not available, say it's an unplanned resignation, the individual quit for whatever reason, make sure that you document that immediately, okay? You must make sure that you take and control the message. Take advantage of it, control the message. If that employee gets mad at you for giving them a written warning and they slam their hand on the desk and say, I quit, make sure you document that immediately. You're not going to get a letter of resignation, and I guarantee you 95% of the time that's the type of claimant that's going to go down to the unemployment office and develop what I called that convenient amnesia. They're going to tell the unemployment office that you fired them, okay? If you can't, and that's not something that we would suggest you doing every time, but consider sending a certified letter acknowledging the claimant's resignation. We use this very effectively in cases where there might be another area dispute, i.e. workers' compensation. Because, say for example, the individual will not come in for light duty and you have made every accommodation that you possibly can, you have light duty available to them, and they will not come in. We encourage, and we've used this incredibly effectively, to send a certified letter to that individual saying, explaining to them what you've done to accommodate that scenario and that their refusal is you're accepting their resignation, okay? So make sure that when you do something like that, you always use the words resigned. If you are, any documentation that you're creating regarding a resignation, use the words resigned or quit, because the unemployment office in the bureaucratic mind, they associate certain words with discharges automatically. The word terminate, for example, is almost always associated with a discharge. And it doesn't matter if the claimant wrote you a 12-page resignation letter, some adjudicators are going to get hung up on this word, this one word, especially if there's a dispute in how the separation occurred. The claimant has to show good cause for quitting your job. Okay? They must show that they've done everything under their power to preserve their employment before they took the drastic act of quitting. Okay? So documentation, again, take control of that message. If you've done things to help them, accommodate certain things, to work through different issues, document that through the process, because that's going to help us show that they did not meet their burden of good cause, especially in things where there might be an investigation that has occurred, i.e. sexual harassment or something like that. The claimant must have given you the opportunity to come to a resolution of that investigation before they quit. They must have told you about the incident before they took the drastic act of quitting. That's all part of the good cause requirement under employment security law. The last thing I want to point out is constructive discharges or discharges in lieu, or resignations in lieu of discharge will never be considered resignations. The case law, all the way, like I said, to the United States Supreme Court, is very clear. For it to be a voluntary resignation, the claimant has to make the first overt act to sever the employment agreement. They have to be the one who severs the employee-employer relationship. So just keep that in mind. No matter how many times or how often you use that, be prepared to fight that as a discharge. You're only determining for the claimant how it's going to look in their employee file. They were never going to be allowed to work past that day. Now going on to the discharges, what you want to make sure you do is you want to make sure you understand what you're trying to prove. And this applies to when you're just doing this in your own documentation. You want to kind of try to keep in mind the burden of proof that we're going to have to show when we're fighting a discharge on your behalf. So try to understand, if you're familiar with it, what in your particular state, what is required to show misconduct or for a discharge relating to attendance. Try to weave that into your documentation process. It's going to make our life easier, make your life easier, and it's going to answer a lot of questions up front that the examiner, the adjudicator, is going to have. Remember, the main thing is proving misconduct is the goal, not justifying your termination of that employee. You must show that the actions of the claimant were willful and deliberate. In most states, okay, well, in all states, at will is not the same as a disqualification. You can release an employee in certain states for at will and not give them an explanation, but that is not going to automatically result in a disqualification in employment security law. You've got to meet this burden of willful and deliberate. Misconduct from state to state to state is generally defined as a willful or deliberate violation of a policy or expectation that's reasonably owed the employer. Negligence, for example, can be misconduct if there's been an established pattern. So it doesn't have to necessarily be absolutely 100% deliberate. You can have certain cases where negligence is misconduct if we can show that there was a pattern in the documentation of a continued violation of a certain policy or procedure. Okay, so But generally speaking, they're going to define that as a willful or deliberate act on their part. The emphasis when they are adjudicating unemployment claims for discharges is almost always on the last incident. The previous warnings that you gave them are used to establish that they were aware of the expectation, that they had been warned about their behavior or their conduct or their performance, but the final incident is going to be about 90% of the adjudication process. All this other stuff that occurs prior to the last incident is helpful because it establishes that pattern, it establishes that progressive discipline. But for example, if you have reprimanded an employee 3 times for 3 different topics and they're fired for a 4th completely different topic, that progression of discipline is probably not going to be as helpful to you as if there was that linear progression. That doesn't mean that you shouldn't fire them. It just means that the documentation is going to be less of a factor because of the final incident, that focus on the final incident. The proverbial straw that broke the camel's back is what they're going to be looking at. So your emphasis in your documentation on discharges, really pay attention to that final incident. Again, do not take anything for granted. I always get the inevitable phone call of how could he get unemployment? He was caught sleeping on the job, etc., whatever it might be. And the assumption is that because it's such an obvious reason for dismissal that the unemployment office is going to look at it as an obvious reason. They're not. They're going to make you show, even in the most ludicrous manner, that the claimant was aware that what their action was inappropriate and that it was willful and deliberate. So keep that in mind. Don't ever take a shortcut, especially on that last incident. Focus on things that you can factually prove. Okay, you don't want to make assumptions. You don't want to speculate. You want to try to narrow that focus down as much as possible and provide good, clear content in your written warnings. You want to be able to say, this is what happened, this is what you should have done, this was the result towards the company. Remember, it's an expectation, it's a violation of a reasonable expectation. So use your policies, use job descriptions, especially companies that are regulated in any way, shape, or form. We tell our clients, like hospitals, healthcare, nursing homes, whatever, if you can tie this to a regulation that's state mandated, that is wonderful, because the unemployment people love it when you can tie it to something that is authoritative. So keep that in mind, that when you're doing that documentation, use every piece of ammo that you possibly can to your benefit. Look outside the box when you're reprimanding employees. Some of you may have already been through my seminar, my larger seminar, and when we talk about attendance, we talk a lot about the difficulties in proving misconduct for attendance-related claims, because the emphasis is never on the number of tardies or absences that a claimant has. It's on whether or not the claimant had good cause for being absent or tardy. So naturally, the policies are in direct contradiction to the state law, because it's based on number, and it's an occurrence-based system, it's a point-based system, whatever, and they don't emphasize the good cause area, the reasons for the absences. But generally speaking, almost all of you have a policy in place where it says what is the proper procedure for reporting absences or tardies. You all probably have a policy in place that says you must contact a supervisor no later than X amount of time before the beginning of their shift, and these are the acceptable means of communication. We have an extremely high success rate of protesting unemployment claims when the approach is failure to properly report the absence or a tardy. And the reason why is because good cause is extremely gray, but failure to report the absence or the tardy is black and white. You either do it or you don't. And if the documentation, when possible, frame your warnings leading with that issue, because that's an issue that is black and white. You can prove that issue, and you're not asking the claimant then to provide medical certification. You're not asking for an explanation. You're getting a black and white topic up front. You're still addressing the tardiness or the absenteeism issue. You're still putting that in the reprimand, obviously, but I guarantee you, more often than not, that claimant is going to violate that reporting policy again, and then you get to go back and terminate them for that issue. And when you do, it gives us a very black and white topic to protest the unemployment claim on. Our success rate for protesting unemployment claims on that issue is nearly 100%. So keep that in mind. Think outside the box. I can think of other examples, and you know, if you have questions about that, by all means, make sure that you come back and ask me about it, and I'll be happy to answer. In your documentation, when you're dealing with terminations, discharges, always avoid using words like unable, inability, does not understand, whatever that might be, because inability, this comes back to the at-will thing. Inability might be a perfectly good reason to release the employee and not employ them any longer, but it will almost never result in them being denied unemployment. Inability or the lack of job skills is not a reason to deny unemployment. It will not meet the definition of misconduct. If the claimant did everything under their power to perform the jobs efficiently and correctly, they just weren't any good at it, that's not going to be misconduct. Okay? You must try, whenever possible, to draw that line between their actions and what was expected of them. And it's not as hard as you think. If you sit down and you use the job descriptions, you use the training to your advantage that you provide these to the claimants, you are going to be able, more than likely, draw a connection and not just assume that it was an inability issue. So, final topic is protesting eligibility. Not all claims involve a separation, and the claimant must be able and available for full-time employment. They have to be able in order to be eligible for unemployment, they have to show that they are completely available for full-time, 40 hours worth of work. You have to raise the issue. When we fight an unemployment claim on behalf of our clients on this topic, we have to raise that issue. You must ask the state to address their able and available issue or any eligibility issue. And that will set up an issue that will not necessarily disqualify them, but will make them temporarily ineligible to collect unemployment benefits. Severance pay is a perfect example of that. Also, work comp or leave of absence. If the individual is on workers' comp and they're not available for any kind of light duty, then you're not going to win on an issue of separation. They're still job attached technically, but you're not going to. The separation issue isn't where you're going to get the relief in charges. Where you're going to get the relief in charges is that you raise the issue of their availability for work, and they will make them temporarily ineligible because they are either on that leave of absence or they are on workers' comp, because they're not able and available for 40 hours worth of employment. Also, even if they've been laid off, you can raise an eligibility issue. If they are laid off and you know that they are going to go back to school and remove themselves from the workforce, you can raise that issue. Obviously, that's something that each employer looks at from a different point of view. But certainly when an individual is laid off, you can raise the severance pay issue if you pay severance pay. If they're involved in some kind of workforce retraining or school or whatever, that can be an issue as well. Again, it doesn't prevent them from being denied permanently, but it buys you time so that that individual is more than likely to find employment down the road, and it minimizes the expense that you're paying for that particular layoff. Work refusals are a very good way of for people who, especially for employers who maintain on-call or temporary employees. For example, hospitals use PRN employees a lot. Most PRN employees don't file an unemployment claim because they don't want to bite the hand that feeds them, but on occasion you have an individual who will be in a PRN employee and file a claim. If you offer that employee an assignment and they refuse that assignment, you can set that up as you can send that in as a separate issue that could result in either a disqualification or it can result in a weekly ineligibility, and would prevent them from collecting unemployment for that week. So that's just a couple of things that you can think about when you're looking at an unemployment claim. There's different ways to approach it. Complete the wage audits that you get. Okay, these prevent fraud and they can result in a credit. What those often are designed to do is to catch individuals who have misrepresented either their wages or some other form of their eligibility. So I know that many employers look at those upon as a nuisance, but it can result in a nice credit if the claimant is caught misrepresenting something associated with their unemployment claim. They will go back and the state will disqualify that claimant for a period of time, and it's often very punitive, and many times they will then go back and they will credit the employers who were affected by that unemployment claim. Finally, I know a lot of you already are here, consider outsourcing your unemployment claims. I mean, for those of you who understand the finance system of the unemployment world, you understand that you pay tens of thousands and in some cases millions of dollars in unemployment cost into a reserve account or through reimbursable charges. That is an incredible, valuable asset that you're using. All this money you never get back. So when you put this money into your reserve account, you need to view that as an asset just like you would a piece of machinery or the roof of your building or whatever, because the only value that that unemployment dollar, those tax dollars have going forward is to drive down your unemployment expense in the future. Keeping that money in your reserve account will drive down your unemployment tax rate and as a result minimize the taxes that you pay over the course of time. And that combined with good claim management can result in an incredible mass amount of savings for you if you really take a comprehensive approach to this. Obviously using an expert will protect your rights and this asset. And then finally, the claim cost can go as high as $20,000. So you want to make sure that there's a lot of money at stake because unemployment is oftentimes out of sight, out of mind. You don't realize how much accumulated expense can be applied to this particular piece of labor law, because it happens over drips and drabs. It doesn't happen, all at once like some things can happen. And frankly, using, I know many of you who already use this, I hope you see the value in this. I mean, you see that, our knowledge and working with our clients to have good, proper documentation, it's going to result in a much higher disqualification rate, and it's going to maximize that tax savings. So the return on investment is extremely high. Our average return on investment is often 50 times the service fee. We've even had clients that are as high as 112 times the service fee. So we can pay for ourselves in very short order, and if you don't currently use a company like us, we would strongly encourage you to explore this as an option. And after that, there's my contact information. I think we got a couple of questions here, so I want to go ahead and talk about those. We are going to be sending out a copy of this. I believe we're actually going to be sending a recording as well, so you can use this if you want to in a meeting or in a training session, whatnot. So you will receive a kind of a recap of that. Susan asked that question. So yes, you'll be receiving a copy of this. And Linda, if the employee gives 2 weeks notice, but the employer does not have them stay the 2 weeks, is that considered involuntary term now, or do you have to pay the 2 weeks? That's a great question, and I skipped over that because of Linda's question. I wanted to make sure that we address that directly. The key to that is did you pay them? Okay. In some states, if the individual gives you their notice and you do not allow them to complete that notice period, some states will consider that to be an absolute discharge without question. Other states will consider that to be kind of a hybrid issue. They will say that during the period that the claimant normally would have had their notice period, say that 2 weeks, and you did not pay them in that 2 weeks and you did not allow them to work, that 2-week period is going to be considered a discharge, and then it reverts to a resignation after that 2-week period. The easiest thing is that one of two things, if you want to avoid the unemployment expense for that area, is one of two things. Either allow them to fulfill their notice period, and it doesn't necessarily mean that they have to work in that same position. You can reassign them, or you pay them. If you pay them and you do not allow them to work, that takes everything off the table and it will be considered a resignation, because the state will determine that there was no financial liability applied to them for not allowing them to work their 2 weeks. Okay, so I think that answered hopefully that answered your question, Linda. So if you have any other questions, by all means, feel free to contact me. So, well, unless there's any other questions, I don't see any other here. So I look forward to sending out some more information as those months go on. We're going to be having, like I said, a series of these, and we welcome you to join us as often as you possibly can. And I appreciate everybody participating, and I wish you all a great day. Thanks a lot.